For the next session on patent filing process, we have with us Ram Jawahar sir. Ram Jawahar sir is a Deputy Controller of Patents and Designs in the Department of Industrial Policy and Promotion, Ministry of Commerce and Industry, Government of India since 2003. He has examined and granted more than 15,000 new inventions. He is a mechanical engineer, obtained his ME Internal Combustion Engineering from CEG Anna University and MTech Polymer Science and Engineering from CEG. He has more than 4 years of teaching experience in Department of Mechanical Engineering. He obtained DL 101 General Course on Intellectual Property Rights, DL 201 Copyrights and Related Rights, DL 202 Electronic Commerce and Intellectual Property, DL 318 Advanced Course in Patent Information Search from WIPO Geneva. He has also obtained PG Diploma in IPR. He has been to Japan for 3 months to study the procedures and the systems practiced at Japan Patent Office. He has also obtained a certificate course in German language from University of Madras. We are happy to have you with us, sir. I now request our Deputy Director, sir, to felicitate, sir. Thank you, sir.
Thank you very much for this wonderful opportunity given. The topic what I am going to handle is intellectual property rights. So many people know about this topic, but previously all the chapters what you have learnt is something how to write your patent specification and write your doctoral thesis and all such things you might have heard. But this topic is something narrowly it's deviated from the original path. Intellectual property rights. If 20 years before, if I talk about intellectual property rights, no one knows about that what is intellectual property rights. In 20 years back, I joined this office. At that time, if I met 10 inventors, out of the 10 inventors, only one inventor is an Indian inventor. All the 9 inventors whom I met are Japanese inventors or Korean inventors, European inventors and American inventors. But slowly the face has changed. The today's scenario, out of 10 inventors, the 6 to 7 inventors are Indian inventors. So 10 years before, if I talk about intellectual property rights, people ask more questions. What is intellect? What is the use of that? There is no use of intellectual property rights. But this is not the case. Now, what is the important? What is the need to study about intellectual property? I think you people know about the very famous story of the Kodak and Polaroid story. Of course, the Kodak is the original inventor, though some people ask Kodak to file a patent. The Kodak, they never worried about patent. They said that what is patent? There is no use of patent. It is something like developed countries are cheating. These days, it's a cheating type. Like that, the people were thought. And what the Polaroid people did, they are not the original inventors, they somehow know about the invention and they file the patent first and they go to the court and what they said is, it is my invention, Kodak copied. Then when it goes to the court, what happened? The decision comes in favor of Polaroid. And Kodak could not pay such a huge compensation. Now the company is exist or not, that's the biggest question mark. That's the importance of patents, intellectual property rights. So many people, they may run a small company for 10-15 years, they are running a company, they are not making any profit. Nobody worrying about their company. Once he start making small revenue, then immediately he receives some lawyer notice and says that what all the product you are manufacturing now in your company is already patented by me in 5 years ago. You have to pay this much royalty. Then only he realized the importance of, so the 5 years term what he earns is a total waste. That's the importance of intellectual property rights. For example, if I ask you the question, what is the purpose of doing this PhD? The 4 years you are doing BE, that itself is a hectic work. And completing BE, then writing GATE exam, then to ME, that also next hectic, and after that PhD. What is the use? Why you are doing? I asked many people, what is the purpose you are doing PhD? Then many people said, sir, somehow I complete my PhD in 3 years time, I will get a good job. And some people said, in my biodata, in PhD means some value is there. That is most of the people answer. And some people says that I will get a good job in some teaching job I can go. These are all the answers. And one person said, sir, our society is facing these are all the problems. For example, the simple problem is mosquito bite. If I find some solution for mosquito bite, our society may be benefited. Which is the best answer? Which one you think it's the best answer? Nothing is the best answer. The best answer is if I ask the same question in Japanese university, sir, using my patent work, I want to earn money. I want to fill my pocket. Nobody think like that. How many of them think that using my research work, I can make lots of money? Nobody think like that. That is the difference between our people and other country people. That is the reason why more inventions comes from other country. But we may have more number of publications. We may have more number of literature survey. I mean, research papers. As compared to other countries, Indian research papers are much more. But how many Indians make money out of your research paper? We are not making money out of the research paper. So, before start your work, my ideology, what I want to say is just do the market survey. What the people are facing the problem? In which work if I choose, I can make money. Think like that. Everything is based on to make money. To make money, what you need to do? So, if I do this work, no need to join in any college. If I sell my product to some American company, they will give a royalty. If I get 10 patents, if I get royalty means then no need to work. Just relax in home and getting royalty. That is more than sufficient. This trend is changed in many countries. But here, our people think about, I want to complete my PhD in 3 years time, join in some college, and what the salary they give. In some of the colleges, the month of May, they are not giving salary because you are staying at home. Then what is the change that mentality, methodology, and you do the proper market survey. So these are all the problems. So some people, they do some satellite technology. This technology, that technology, there is so many beautiful technology. After that, how much using this invention, how much money you earn? Nothing. Some people may do very minor work like mosquito arrest or something like very small like the cleaning the drainage. It's a very ordinary work. They might have earned more money. So this is like, it's a documentary movie director and a commercial movie director. So our people are always documentary movie director. Documentary movie, so many good stories are there. All the sentimental issues were there. You will get Golden Globe Award, Filmfare Award, so many awards you may get. And every newspaper talks about you. After 5 years, have anyone met that producer of that particular documentary movie director? Nothing. He may get so many awards, but in his pocket, nothing available in his pocket. But other director, but nothing is there. Some commercial movie with one dance and some fight and something else and with good hero. Using that, they might have do some commercial movie. He might have that nobody appreciate, everybody criticizing the subject matter. But think about the producer, how much money he has in his pocket. So decide, you want to be a documentary movie director or commercial movie director, right? Solution, or you think like that, solution to the problem. For example, the people are facing problem. Once in one tunnel, one person, then Sujit or one child, he fell into the tunnel. That time government spent so much of money to take the child, taking out from that hole, but some of the people got patent for that particular invention. We contacted the people, sir, whether my invention will work or not. So whenever the problem happens, whether it is useful or not useful, that's a question comes. One thing you make money, other thing help the society. Think like that. So you protect your invention. How to protect your invention? This is not the new concept. It is a very old concept. Very old concept in the sense the Paris Convention. In 1883, the Paris Convention, it is mainly to protect design. Paris Convention mainly to protect design. What is design? For example, something like my daughter, she wants one pencil. In the pencil top, some Dora Buji, something like that, it's pinched at the top. Actually, the pencil cost is how much? 5 rupees or 10 rupees. Just because this Dora or something else, the cost of the pencil is now 90 rupees. This is a value of the design. This is a value of design. For example, the Hyundai car is there, Hyundai Accent car is there, Hyundai i20 car is there. Both the car has a cc of 1200 cc, same transmission system, same exhaust system, everything is same. But one car sales is much more than other. What is the reason? Design, the value of design, the color, and although we can register for the design also. So some people say about it's very easy to get the design thing. The patent is the 20 years. The lifetime of patent is 20 years. And design, the only office available in India is in Calcutta. You can file a design application in the Chennai patent office. We will forward the application to Calcutta. And Berne Convention, which talks about copyright. What is copyright? If suppose you write some book, so you need to get the copyright protection. Else, what will happen? Someone will copy your invention. Some people may ask the question, sir, I take a foreign author book and full Xerox, is it a crime? Definitely. It's a criminal offense. But our people are still doing in copyright offense. In one college, one engineering college, they have a big computer lab. All the nearly around 500 computers. All windows are cracked version. We think that nobody is watching. Even in our home also, many people, how many of them is having the original this thing that nobody knows? Most of the people are having cracked version, and finally those people are watching us. The actual fine they given to that particular college is 4 crore fine. So some people are, nowadays it is not the strict of, many people think that it's a part of life. If you are using that fake version, it's a part of, it's actually speaking, it's a offense. And the Rome Convention, it is a broadcasting rights. If, for example, the cricket match is coming, who can telecast? Only Jio Cinema can telecast the Olympic sports. Others cannot copy that one. If others copy that, they can copy only after 25 years. 25 years they have all the right. The broadcasting right is 25 years. Copyright is after death of author, it is 60 years after death of author. That is the reason why the story of Ilayaraja and SPB happened. So the copying is actually, who is having a real owner? That question comes into the mind. Nowadays the A.R. Rahman is making some music. What he do? If a producer is paying some huge amount, he make on separate agreement. Even though you are paying the money, the music rights is always rests with me. So previously during the Ilayaraja period, he doesn't make such a separate agreement. What the producer is saying, I already paid the money to music director. So the rights with producer, like that it's saying, but no such special agreement. Then in that case, the government is saying that 5:3:2, all the people can share the rights. That's the importance of the Rome Convention and Madrid Protocol. This is about trademark. You need to register the, what is a trademark registration? For example, one student, he attended the counseling and Liba like some college he chose, but he never knows that is it original Loyola or other Loyola. So these are all because of trademark issues. If you register your trademarks, others cannot use the name. Previously that biryani called Talapakattu. Every road corner you may see that the yellow color board, everybody used the word Talapakattu biryani. Once they go to the court and the judgment came, immediately they given a clear cut judgment says that this is Dindikkal Talapakatti. This one is Chennai Router Talapakattu. The very next day they changed the board. Okay, this is not the concept what we have not created. So everything is binds with WTO. What is WTO? World Trade Organization. From 1st Jan 1995 onwards, we became the member of WTO. So before WTO, the organization called GATT. Have you heard about what is GATT? GATT means General Agreement on Tariff and Trade. General Agreement on Tariff and Trade. What is the difference between GATT and WTO? There is no difference. GATT becomes WTO. From 1st Jan 1995 onwards, the GATT becomes WTO. In GATT, there is no dispute settlement body, but in WTO, we have a dispute settlement body. So now all of us became the member of WTO. India became the member of WTO. Your contribution, your small invention that boost our GDP or economy. How the small inventions can boost our economy means there is some of the inventions, something like that. I met one inventor, one section called anything which is frivolous and contrary to well established natural law, it's not patentable. But I met one inventor, he uses the motor pump and initially he gives some energy and getting that continuous water output or something else. After that he switch off the supply and continuously it has come. What he says is the flywheel converter. Using the flywheel which stores energy, from that the continuous energy output he is getting. Here what happens, the output is more than input. Is it possible output is more than input? It is again second law of thermodynamics. What is second law of thermodynamics says? Output cannot be more than input. நீ ரெண்டு இட்லி சாப்பிட்டனா இவ்வளோ தான் ஒர்க் பண்ண முடியும், இவ்வளோ பண்ண முடியுமா? It's not possible. But one person, how he is getting this much output without the input? And Punjab government given rights for the person to, he make a big flywheel and he is getting the energy. So this person has made an agreement with many countries. Most of other countries, that money which comes to India, that is very small invention, our economy. Okay. So that is the reason why the government of India is taking care of the inventors. If you do the beautiful invention, some of the beautiful inventions are more than sufficient to boost Indian economy. We think that our invention is just to getting a job in some, it's not that. If you do some beautiful inventions, automatically you are indirectly contributing our GDP growth, right? You think these things in your mind, then you do the project work. So when India became the member of WTO in 1st Jan 1995, the main purpose of WTO is free trade. Free trade. And immediately the many people are criticized India. India is a developing country. America and Europe and these countries are developed countries. Is it necessary the developing country to become the member of WTO? There are so many criticisms. So the criticisms like the main purpose of WTO, what it says is subsidies. Stop all subsidies. But our country is having so many ration shop. Poor people are there. Subsidies are against the nation growth. So many people, I mean, that's a WTO says like that. But we cannot, because unless otherwise our people comes to some level, we cannot go against it. That thing was there. Then compulsory import. What WTO says is 3% of compulsory import. But what government of India is giving justification is 93% of global business is under WTO. We are not self-sustained with all the things. We depend on petrol to some Gulf countries and other material to other countries. Even China became the member of WTO. If we are not becoming the member of WTO, then what will happen? We will be isolated. The கிராமத்திலெல்லாம் ஒருத்தர் தனியா இருந்தாங்கன்னா அவரை ஒதுக்கி வச்சிருவாங்க. So you cannot develop. So we are in this situation. So what we need to do is, we need to invent more things, and our inventions must go to other countries. From other countries, we must get the royalty from other countries. Then automatically we also compete with the countries. Then our GDP will grow. This is a justification that government of India gives. Like 3% of compulsory import WTO says. But how much percentage of import we are doing? In some of the sectors, we are importing around 40%. So that factor does not affect. And people says that it is patented seeds. Patented seeds means it's something like a BT cotton and all those things. Then again we need to beg to other people. It is not the case. We have the special act to protect Indian farmers and Indian inventors. The section 3D is there. And so many act to protect our poor people. And then some people says that when we become the member of WTO, medicinal prices will go up high. That not good. It is depends on supply and demand. For example, some doctor is writing a medicine means the same formula may be available. Other company is giving 100 times cheaper cost. But the doctor is writing, he never write the formula. He writes the company name. So this is also, this type of facility is also available. This is the importance of WTO. Then how we make all the patent laws is, the governed things are called TRIPS. TRIPS means trade related intellectual property rights. Based on TRIPS, already we became the member of WTO. The TRIPS, they made one guidelines. Based on TRIPS only, our Indian Patent Act we drafted. So the TRIPS, what they say is how to make a patent law, how to make a trademark law, how to make copyright law, and semiconductor rights, and plant breeder rights. There are so many rights are there. Even in this one, intellectual property rights, we made a this called a TKDL. What is TKDL is nothing but, what is TKDL? Traditional Knowledge Digital Library. So the earlier session, one research scholar, he asked a question. It is said in Kalit Tohai and all these things. So all those things which is documented in TKDL, that is traditional knowledge. You cannot get patent for the traditional knowledge. For example, the recently 15 years back, two Americans they got patent for manjalukku patent vaangitaanga. So this is our traditional knowledge. So immediately we people objected. ஆண்டாண்டு காலமாக நாங்கள் யூஸ் பண்ணிட்டு இருக்கிறோம்னு சொல்லிட்டு we given all the proof. Then they revoked, the patent revoked. Okay, something like that. And the neem also, manjal neem. And finally we came to know that the person is not American, who is an Indian who settled in America. He got a patent for turmeric. Then immediately we objected. Very next day, then all those proof we submitted, it's a patent revoked. Then like that, the basmati rice, some Americans, they got patent for basmati rice. So after that, actually the particular invention with the 20 claims, we given so many objections. and after that they deleted 14 claims, only 6 claims were accepted, and they say that it has some advantages than the Sindh Basmati. So, what they say is it is something like Texmati. Texmati in the sense, America, the biggest state is Texas. It grows only, even in Texas climate it grows. Texas climate sometimes it goes around 55-degree temperature, and in other month even in becomes 10 degrees. So, that a huge variation, in the huge variation that may grow. So, basmati rice and manjal, apra neem, and all these things, that thing was revoked. And WIPO, World Intellectual Property Organization, even though we are working under Ministry of Commerce and Industry, how the intellectual property rights should function, the guidelines is given by WIPO, World Intellectual Property Organization, the head office at Geneva. So, main thing is promote IPR and administrative cooperation among the unions. There is separate, previously the WTO take care of IPR rights. Now there is bifurcation between the WTO and WIPO, what the subject matter WIPO deals and WTO deals, and mainly for intellectual property rights fully governed by WIPO, World Intellectual Property Organization. So, IP, intellectual property, is a creation of intellect in industrial, scientific, literary and artistic field. Artistic field in the sense the copyright related things, literary, writing books, and industrial, scientific means patent. So, the right given to intellectual property is IPR rights, it is a territorial rights. You can get a patent in India, but it is not valid in US. But no one can get your same invention in US patent office, there the controller and the examiner will object, right. So, as per Indian Patent Act, section 3K is there. As per section 3K, software patents, as per American Patent Act, even the software programs are patentable. As per Indian Patent Act, pure software programs are not patentable. Software coupled with hardware is patentable. So, easy to get a patent. People may easily say that anything under the sun is patentable in US, but it is not the case in India. Okay, that chapter I will deal about that sections and all those things. So, the exclusive grant provided by the government of India for limited period of time. So, patent, what is a limited period of time? Today, if you are applying patent means your lifetime is only 20 years. After 20 years, that becomes the public property. Anyone can use that particular invention, right? Up to 20 years only the patent has the right. And what is the advantages of patent? Advantages means duplication of research. The word, that's beautiful word, duplication of research. The biggest enemy to our research scholars is the duplication of research. So, before joining this patent office, here I worked in mechanical engineering for 5 years in CEG. That time we used to go to some of the colleges for external examiner. I go to some college and one student started explaining his invention. I impressed, our BE students are doing this much beautiful works. I had given very good marks, yes grade. Then within 10 days time interval, go to other college, other student also started explaining the same invention. Then I asked him to stop, this is a result you are going to get. Where you copied? He started crying. Sir, I didn't copy it. Yes, I accept you didn't copy. Where you go wrong? He didn't do any literature survey. Many people are not doing proper. In our days, if literature survey itself is, we took 6 months to 1 year. We go to library and see all the journals. But now it is not the case. If you go to Google, within 10 days time you can do the proper literature survey. Do the proper literature survey. The duplication is biggest enemy to all our research scholars. So, finally, once I go to HVF, heavy vehicle factory, for some seminar and those things, on the way I saw one board, engineering patents. Then one phone number was there. Immediately I note down the phone number. Engineering patents, sir, what work you are doing? You are just, the board says that engineering patents. Then immediately, sir, what are you doing? I am a research scholar, I said. Sir, BE project is 5,000, ME project is 10,000, 3 BE project is ME project, and for PhD this much work we will take care of everything. No need to worry. If you pay 95,000 rupees, I do proper drafting and everything. Definitely people will accept, sir. This person is earning lakhs and lakhs of money. Don't follow. Then only I came to know that, oh, from this person only these people demonstrated the product. Oh, he is the original inventor. Please don't follow this part. No need to do the satellite technology. Even you do the very small technology on your own. Okay. This is the duplication. Avoid this duplication. It is the biggest enemy to Indian economic growth. Then latest developments in different fields of what is a developments in different the particular field, so that you understand and help the industry to improve existing technology. One solution is there. The problem you already found. For that one solution is there, and you can find out some other solution in some cheaper cost. That is also patentable. Not only the product is patentable, even the method steps are patentable. Process steps are patentable. The process alone you can get patent. So once you get a patent, what some people they on their own they do manufacturing. Or if you feel that it's not possible for me to do the manufacturing work, means you can very well they submit their patent to other company and they give royalty to you. So that procedure also you can follow and serves as an indicator in achievement in R&D institution and ability of individual researcher. So encourage the inventors work the patented inventions in commercial scale. So commercial scale you keep it in mind. Nobody in the PhD work, how many of them commercialize for the past 5 years, so many research scholars come out. How many of them commercialize your PhD work? How much money you earned out of your PhD work? That decides the country's future. So commercialization is very, very important. I completed the work, but my thesis is sleeping somewhere. From the thesis, how much I earn? That question. And patent not granted for mere importations and patented articles into India. And some of the things, if you want to do the patent, there are 3 things that is very, very important: novel, inventive step, and industrial applicability. What is this novel? Novel means one clear-cut document that kills your invention. Only one document kills your invention. The simple way of defining inventive step is, you take one portion from one invention, other thing from other invention, and third one from other invention, and combining these 3 things you make a new invention, means that we object under inventive step. Most of the patent objections, we raise objections based on inventive step. We cite the documents. Document 1, American patent document. Document 2, EP document. Document 3, Japanese document. And this portion you copied from American document, European document and Japanese document, and you make a new patent. So this is inventive step. And the third one is industrial applicability. So before doing your, filing for patent, so some of the things which is not patentable as per Indian Patent Act. The first thing is section 3A of Indian Patent Act. Anything which is frivolous and contrary to well-established natural laws are not patentable. Well-established natural laws, that's what I said. Second law of thermodynamics. Someone says that Newton's law is wrong. They make some invention, means, and our machine is giving how much it is output, 45% output it will give. If you say that the machine is giving 80% output, then he done some value change, something else like that. So this is against the second law of thermodynamics. So what is that says that the, what is that Kelvin Planck statement? What is Kelvin Planck statement? Mechanical engineer? I forgot that. And one more thing is that called that Clausius inequality. Can anyone define that Clausius inequality? So when it is against these Kelvin Planck or Clausius inequality, the output cannot be more than input. The simple way of understanding that is not patentable. One inventor, he comes to me and he demonstrated his invention. He kept the flywheel. That is, flywheel means there is vertical axis flywheel and horizontal axis flywheel is there. One vertical axis flywheel he fixed at the top of the train and every coach he fixed. And initially to start the engine using diesel, he started the engine started moving. After our time, what he does is he stopped the supply of diesel. Then he is getting windmill energy. From the windmill energy, I am running the train. Some model also, some prototype also he created. If the inventor comes to you, do you grant the patent? Patent grant பண்ணுவீங்களா? If suppose you are a patent controller, do you grant the patent? நல்ல ஐடியா தானே? எவ்வளோ how much diesel we are wasting? Can you grant the patent? But yeah, he made some prototype also. But we didn't grant the patent. What the input energy he is getting from wind energy, at least to inside the compartment, some light, some fan, that energy is enough for only that, not to run the whole train. That energy is not sufficient. Here, the output energy is more than input. Okay, that is not possible. So it was not granted. Something like that. One inventor, the 15 years before he met me, his name is, I forget his name, the Moolihe or something. Ramar Pillai, he comes to me and he demonstrated his beautiful invention. Sir, I have done this one and 2 ரூபாய்க்கு பெட்ரோல் தரேன் அது இதுன்னு எல்லாம் சொன்னார். Then thoroughly we examined and we raised so many questions and asked him to answer, give an answer within, that time it is 12 months time. When we give a first examination report, 12 months time, within 12 months time he is supposed to give answer to all questions. But he didn't give any answer within 12 months time, so the patent refused. So then finally, what is his composition contains means some leaves he is using and all those things. Some benzene composition is also, he used that benzene composition and something like that. But you have to prove that because of the leaves, how much energy you are getting. That is very, very important. How much energy you are getting, that particular composition of the leaves or whatever these things. That he fails to prove. Then after that, there are so many cases has happened and many problems he faced. So these are all the one things. Inventions frivolous and contrary to well established natural laws. The output cannot more than input. And second thing is, the invention contrary to law, morality and injurious to public health. Anything which is injurious to public health, that is not patentable. மசாலா பவுடரில் செங்கல் தூளை எப்படி கலக்கிறதுன்னு ஒரு சூப்பராக ஒரு டெக்னிக் கொடுத்தாருன்னு வைங்க. That is not patentable. It should be for the good cause. I met one inventor. He make one beautiful belt. Met one inventor, one beautiful belt. Belt has some sensors and all these things. And what is the use of the belt? And he said that if a pregnant woman wears that belt, the belt will say that after some time it is boy or girl. No need to go to the gynecologist. That's very good invention. Is it patentable? It is against our law. You go to US or you go to Australia, there it is allowed. But here it's not allowed. That is morality, the contrary to morality and injurious to public health. And section 3C, which is not patentable, formulation of Einstein theory. Many people still today they come to patent office and says that, sir, what Einstein wants to say, E is equal to, what is Einstein means? Everybody will say that E is equal to mc squared. After that, can you please elaborate? Nobody gives proper things. And some people, they given some solution and all these things. There is no proper proof. There is no proper proof. Some people in 20 years, 15 years before, one group of people from CEG come to patent office and they met me. And sir, the Einstein equation, I have found out the solution. This what he tries to say, sir. If you do like this, we can do this magic and all these things, he said. Then I didn't understand anything, what he tries to say. So, from where you get the idea from, how is it possible like that? I asked the question. Sir, I directly asked doubt to Einstein. Einstein direct doubt. So, some people in 15 years before, in 12 o'clock, some candle, something, he moves and he calls Einstein Kupta avarte doubt clarify panna. This is not patentable. And section 3D, only country which has the section is India. No other country has this section. The discovery of new use of known process. Previously 15 years before, one drug, the Suds company, they found the drug for cancer drug. All the countries, whole world granted patent for the Novartis drug patent, but only country refused is India. So, the remarkable improvement, the lifetime of patent is 20 years. What they do is, in 18th year, they come up with some other solution and they will get another 20 years term in 18th years. And a small modification they may do, whether it is a remarkable modifications, what is the percentage of improvement, that also, this term is called as evergreen patent. In paper they used to call this as a evergreen patents. So, that one only country refused is India, then they challenged our decision, they go to IPAB, Intellectual Property Appellate Board. Now the Appellate Board is abolished, previously Appellate Board was there also we won, then they go to challenge our decision and go to High Court 5-member bench, that we won the case. Then finally Supreme Court, finally the company, Novartis company, they lost the case. They actually the decision comes in favor of Indian Patent Office. So, composition of admixture, something like that, you mix 2-3 compositions, some mortar compositions, something like water and civil engineering, there is so many compositions are, what is the outcome? Already available things, the comparative sense, how much percentage of improvement you get. So, nothing is there, just a mixture. Because of that, what is the use as compared to already available use? So, that is not patentable, and many of the mechanical patents biggest hurdle is mere arrangement and rearrangement of known devices. Arrangement and rearrangement of known devices. The very old example people used to say, the umbrella fitted with fan. If you take one umbrella, then lift the umbrella, then here you fix one fan, put the switch, then fan will rotate. This operation is separate, this operation is separate. It is not patentable. Sir, everything is not patentable means then which one is patentable? So, previously when we drive the car, if you put a right indicator, what will happen? Indicator will blink. Then you make your steering straightens, the indicator will not comes to rest. Pinadi varra thittitu povan, indicator off annan. That is not patentable, but this is not the case today. You put a right indicator, make your steering straighten, automatically your indicator comes to rest. So, this one is patentable. Even in wiper also, if you switch off the wiper, there itself the wiper stops. Now, it is not the case. Then it goes to 2 rotations, then comes to rest. Actually, the inventor is not from every company is the 30% of their income is they are spending for R&D. R&D people not invented this. Very ordinary person, in one mechanic he invented this particular technology, but using this technology the company made lots of money. Then the inventor asks, sir, it's my technology. So then finally the company show the letter. Before joining any company, they give so many papers to sign. Whatever the inventions you make, even in, I don't know whether it is there or not in your Anna University, that something you might have signed, the invention belongs to Anna University or you, or what is the percentage between you and Anna University. So many documents we sign, we never know that what documents we are signing. So he didn't get any money. But the same case it is happened in Japan. One inventor, blue LED, he made the blue LED. His name is Nakamura. His name is Nakamura. The company called Nichiya company. He worked in the company called Nichiya. He made a blue LED. That time the company given, he appreciated the person and given 20,000 yen. What is 20,000 yen? Something around 10,000 rupees. 10,000 rupees is nothing. But the LED, the company made crores of money. Then immediately he approached the court. And court given the beautiful decision, even though this person has given this agreement, but the money you earn from his knowledge is much more. You need to give this much, such a huge money he got. Immediately he resigns his job. Now he settles in US, right? Nakamura. And plants, animals, anything which is related to GMO, genetically modified things, that is some restrictions are still there. GMO is patentable, but with some restrictions. And when we talk about GMO, something around one story that recently, 5 years back it is happened is, have you heard about Angelina Jolie? Yaar Angelina Jolie are Hollywood actress. So that company is called, one company, they got patent for one testing technology, method of doing the particular test. The test is called, what is it called? The woman has a gene of BRCA1 and BRCA2 gene. So everything is, one person is doing a same bad habit, he is not affected by one disease. Other person is without any bad habits, there are so many disease attack. So one gene, if a woman is having BRCA1 and BRCA2 gene, 100% chance of getting breast cancer. That is their invention. That is their invention. And the invention cost is around $4,000 US. Invention cost is around 4,000, such a huge cost. So few people opted for the test in US, and one day Angelina Jolie, she opted for the test, particular test. And unfortunately she has BRCA1 and BRCA2 gene. What the doctor suggested is 100% chance of getting breast cancer. So immediately she opted for double mastectomy. Immediately she opted for double mastectomy, and immediately she wrote one book, how she suffered, and because of this invention, how I saved my life. All those things, one book, and every US lady read the book, and very next morning all the US lady, they stood in the queue to opt the particular test. In US, everything is covered under medical insurance, but the treatment is covered under medical insurance, not the testing procedure. So since because many people opt for that particular test, Obama, he made that act. During Obama's period it happened, Obama Care Act, in that one he included this testing procedure also. So that company, the Myriad, the company name is Myriad, this company got the patent for this method of finding out the presence of BRCA1 and BRCA2 gene in the body. So nowadays, where the research is going is, if some disease means the curing is one procedure, if a person is having this type of gene, no disease will attack. So you decode that particular gene, and if you inject that particular gene means, then you may escape from disease. So the research goes in this way. This is one such example. Okay. So, this is about that. Then 3K, section 3K is mainly for the computer science and electronics people, anything the mathematical, business method and computer programs. As such, computer programs are not patentable, but computer programs which is coupled with hardware is always patentable. When we joined in this office, that time I met one inventor. He is very ordinary person. His name is, what's his name? He is from Madurai district. One person has come, very ordinary person. His name is Ram Kumar. He come up with one idea. The previously, we have in early 1998, 99, we have mobile phone of this. ஒரு செங்கல் சைஸ்ல ஒரு மொபைல் ஃபோன் வச்சிருப்போம் பார்த்திருக்கீங்களா? அதுல வந்து ஒரே ஒரு SIM card தான் யூஸ் பண்ணுவோம். Only one SIM card we use. But this man, he created the structure for 2-slot SIM card. He created the structure for 2-slot SIM card. And we did that search in all the databases. Nobody has filed the patent for particular things. We granted patent for Ram Kumar. Very ordinary person. So what we do, if I get a patent means what most of us will do, அதை அப்படியே ஒரு ஃப்ரேம் போடுவோம், வீட்டில் மாட்டுவோம், வாட்ஸ்அப் ஸ்டேட்டஸில் போடுவோம், இன்ஸ்டாகிராமில் போடுவோம், எத்தனை லைக்ஸ் வருதுன்னு பார்ப்போம். Am I right? But what this man did is, he go to customs, that airport customs and naval yard customs, and says that, sir, I got the patent for this particular technology. There are many phones which comes from Korea and Japan with double slot SIM card. Please don't allow all the phone inside India because I got patent. But unfortunately, patent word is new to the customs officials. What is patent? Even when I go to, before joining this office, some medical examination procedure was there. That time I go to MMC, the doctor is supposed to give a medical clearance. Then only, sir, what post you are applying? He asked me. I said, patent examiner, sir, I said. Then what we are doing? We are also doing the same. Sir, you are patient examiner, sir, I am patent examiner. That time the awareness, only that, and immediately very next day the assistant commissioner called. Sir, one person, yeah, patent rule says like that. This what our patent act says. It is under the guidelines of WIPO. This global right is there. This one is all those things we explained. And 2 days he said, and all the mobile phones dumped in customs yard. So customs yard is filled up with mobile phone. The assistant commissioner don't know what to do. Then very next day, 3 days after, the joint commissioner comes to our office. Sir, what to do, sir? This becomes a huge headache for us. And we given all these WIPO draft and WTO draft and our act. Sir, this what it says, all those things. But whether our officials, but nowadays there is some provision in Customs Act, that is so many changes has happened in custom, I think section 10C in Customs Act, some changes were happened. So previously that is new to this particular terms. Whether he aware about this procedure or not, the Korean companies and Japanese companies, they very well know about what is Patent Act. In the meantime, he called that particular inventor Ram Kumar, what do you want? I got the patent. Then he said, sir, give me 35 rupees per piece, royalty. Agreed. In 35 rupees per piece, he within some span of time made crores of money. Then very ordinary person, and Mylapore he make one beautiful office with some secretary generals, all those things he made. And some of his friends came and advised, hey, why you are asking 35 rupees? These people are earning in crores of money, ask more. Then he asked for 100 rupees. Then he asked, they agreed. And after that, when it goes like that, what will happen? Then they file the case in court. Then they file the case in court. Why they go to the court? It's again, it's biggest question mark. For example, this becomes some trend. Have you heard the term called a patent terrorist? Patent means inventors are there, patent terrorist, the term is there. For example, if he said about Microsoft, Microsoft is tomorrow they are about to launch one beautiful product. They are releasing date is, that means some company they never know what Microsoft is inventing. But roughly they know about this is a research work is going on. So roughly they make one patent claim and they file a patent in patent office, definitely he will not get a patent. But the term for getting the procedure is at least 3 years it will take. So tomorrow they are going to introduce the product, previous day he filed the case in the court and says that it is my product. For example, Microsoft is copied. He will not win the case. Definitely this person will not win the case. Then what will happen? If anything goes to the court, not only in India, even in US, minimum it takes 6 months time. 6 months time, just calculate the loss for Microsoft. How much crore loss? Then one term called in US outside settlement. For most of the cases, outside settlement. Case நல்லா நடந்துட்டு இருக்கும், கோடிக்கணக்கில் செலவு பண்ணியிருப்பாங்க, லாஸ்ட்ல they go for outside settlement. Okay, immediately நான் கேஸை withdraw பண்ணிடுறேன், you give me this much crores. The crore is nothing for them. Some people they are earning like this. நம்ம கஷ்டப்பட்டு PhD பண்ணி இது பண்ணி ஒரு காலேஜில் சம்பளம் கொடுப்பானா இல்லையா நம்ம பண்ணிட்டு இருக்கிறோம். இவன் சாதாரணமா crores of money. So you cannot punish these people. இவரை எந்த லாலையும் பனிஷ் பண்ண முடியாது. Even some of the companies, even in India is also there. The company is run by the toppers of IITians. To make money, that's all. No law will punish me. You people are trying hard and making small amount of money. My brain work, I can get crores of money within a year time. These people called us, the Sun magazine, they termed these people as patent terrorist. So this is about that in software related things, people are making lots of money using patents, and literary, artistic, dramatic and holograms works, television productions, these are all covered under copyright, not the patent right. And mere scheme and rule and method of performing mental act and method of playing game. Sachin Tendulkar cannot claim patent for this way, if you play, you will get more runs. Vishwanathan Anand cannot claim these type of things. These are all the, but any invention which falls under anything uranium, thorium, plutonium means we don't grant the patent, we immediately refer your patent to DRDO or BARC. Once we get the clearance from DRDO or BARC, then only we grant the patent. If suppose you invent something, you keep it in mind, don't disclose your invention to anyone else. If you disclose, many people they file the research paper, then they come to patent. Before that, many people copied your work. So the timing is very, very important. Once that strikes into your mind, immediately you file a patent. If I ask you the question, who is the inventor of telephone? Alexander Graham Bell. This Alexander Graham Bell, he approached the US patent office in the morning, and have you know about the person Eliza Gray? He approached the patent office in the same day afternoon. He never copied, but nobody knows about who is. Same day, because of some traffic issues, he reached the office in the afternoon, he reached the office in the morning. Everybody knows who is Graham Bell, nobody knows who is Eliza Gray. There is so many confusions. For example, like if I ask you the question, who is the inventor of radio? Marconi. Marconi, he is the inventor of radio and he got many patents. And after that, the person called Tesla, he challenged his invention in the court. Marconi, he died in the year 1937 and Tesla died in the year 1944 something. And after death of Tesla, 6 months after death of Tesla, US Supreme Court, they passed a judgment and says that all the Marconi's inventions are invalid. All the rights goes to Tesla. ஆனால் இன்னைக்கும் நம்ம டெக்ஸ்ட் புக்கில் கொஸ்டின் அதான் கேட்பாங்க, ஹூ இஸ் அ இன்வென்டர் ஆஃப் மார்க்கோனினா குவிஸில் கூட மார்க்கோனின்னு சொன்னால் தான் ரைட் ஆன்சர். ஆனால் இது எப்பயோ சுப்ரீம் கோர்ட் தே சேஸ் தட் த ரியல் இன்வென்டர் இஸ் Tesla. So don't delay the period. Once you delay the period, something like invention means many people think that it is very, very difficult one. It's not a difficult. Can you able to guess this invention? Very small thing, one person made lots of money. Can you able to guess what invention it is? Guess பண்ண முடியுதா உங்களால? ஒண்ணுமே கிடையாதுங்க, simple invention. For example, குழந்தை பிறந்திருக்கு, 6 months old baby. If it's continuously crying, what you will do? ஆம்பளைங்களுக்கு தெரியாது, மேல் they doesn't know the pain of women. ஸோ அவங்கள தூங்க வைக்கிறது வந்து ரொம்ப கஷ்டம். Whole night the lady walks here and there and that's a hectic, பெரிய ஒரு ப்ரொசீஜர் அது. But Indian woman has a patient. But US woman, they doesn't have the patient. So one invention has come, you keep that helmet in the baby's head and some input value will ask, it is 6 months, okay. And for that it gives some massage like thing, automatically the baby will sleep within 20 minutes time. This is an invention. So when you sell this particular invention in India, nobody will buy. நம்ம என்ன நினைப்போம், ஐயோ 6 மாச குழந்தை ஏதாவது ஆயிருச்சுன்னா இதுல ஏதாவது சைடு எஃபெக்ட் இருக்கும். We have the patient. நம்ம இந்தியன் உமன் பண்ணுவாங்க, பட் யூஎஸ் உமன் அந்த பொறுமை கிடையாது. So this is very ordinary invention. இதுல வந்து he makes lots of money only in US. If the person introduce this product in India, nobody will buy. These are all the simple procedure. Patent means some of the proper forms are there, form 9, request for examination. For lady inventors, if one inventor is lady, there is some sideline path is there. Okay, that is express way of examination is always there. The recently in the cabinet, 2 years back in the cabinet meeting, they approved that if one inventor is lady. The previously, if you apply your patent in the college name, the fee is much more high. The recent amendment, cabinet amendment, they made that college also same fee as what the individual inventor paid fee. So this is a very simple procedure. Once you file a patent, we will send the first examination report within 12 months. I mean, nowadays it is 6 months time. You are supposed to give a reply. Once the reply received, we ask for some hearing notice. We will give one hearing notice. No need to come to patent office. Just a video conference link we will send. You appear in video conference link. Then we ask some questions. And once you are fulfilling all the criteria within 15 days, then after that some time limit we will give. You file a reply. Then patent will be granted. This is a simple procedure about patent. And compulsory license, one procedure called compulsory license. The company called Bayes and Natco. Why the compulsory license procedure is issued is, the Bayer company, they invented one medicine called some cancer medicine. Its a trade name is Nexover. Actually that term is sarafenib-tizolate. So what is this medicine is cure the cancer patients, but not complete cure, extending the lifetime of the cancer patients. So this one, their cost is actually 2,84,428 rupees. That is 120 tablets for 1 month. This is the cost. He got the patent. But for that the amount is such a huge amount. Ordinary person cannot afford this type of things. So in this scenario, you can give compulsory license. So what the compulsory license, the judgment they have given is, Indian company called Natco, they said that the same 120 tablet I will produce in 8,880 rupees cost. Then immediately he goes to the court and says that, sir, why I am charging this much cost is, For R&D, I spent crores of money. So how to get back the money? And finally, given the beautiful judgment called, okay, let NATCO be the producer. But NATCO will give 6% royalty to Bayer company. And NATCO is supposed to give 600 people per year the free medicine to, adan WhatsApp la or message varum. Go to Cancer Institute, the free medicines available. It's the outcome of this compulsory license. This one is the gene patenting. I said that, Angeline, this is a PCT application. The application called, if you apply patent only in India, you can apply the same filing date, priority date, you can go for convention application. Within 12 months time, if you go to other countries, then priority date starts from first filing date from India. And this is PCT application, Patent Cooperation Treaty. If you file a PCT application, what we do is, we forward your application to Geneva, WIPO. And WIPO will forward your application to all the member countries, 152 countries. So your patent will be forwarded to all the countries, then the examination report will comes to you. That time, which are all the countries you want, you can choose and you can lead the procedure. That is called a PCT application. One application is called convention application, PCT application, then patent of addition. Once you file a patent and something else will comes into your mind, and using the same parent application number, you can file more information. That is patent of addition. Then divisional application, one procedure is there. So this is separate patent. This one is, if you cannot file 2-3 patent in the same name. So can you able to guess this one? This is a very funny invention. Can you able to guess this one? Very interesting invention. Patent na romba vandu idella nenikadinga. Alarm type. So okay, I will give you a hint. What the problem Indian ladies are facing from husband. Indian wife facing, there is so many problems. What important one during night? Snoring. Korata viduvanga. It's a horrible thing. Indian husband, the snoring is, அதை வெளியே கூட சொல்ல முடியாது. And ஒரு படத்தில் கூட இந்த மை இண்டியன் கிச்சன் சம் மூவி இதெல்லாம் இது பண்ணியிருப்பாங்க. ஸோ ஸ்னோரிங் இஸ் சச் அ ஹாரிபிள் திங், அதை வெளியே சொல்ல முடியாது. இஃப் சேம் திங் ஹேப்பன்ஸ் டு அமெரிக்கன் லேடி, இமீடியட்லி ஷி கோஸ் டு த கோர்ட் அண்ட் அப்ளை ஃபார் டைவர்ஸ். ஸ்னோரிங் அவ்வளோ ஹாரிபிள் திங். பட் நம்ம விட்டுட்ருப்போம், அவங்களுக்கு தான் அந்த தலைவலி. ஸோ ஃபார் தட் ஒன் பர்சன் he found one invention. He did a research. If you sleep like this, your snoring sound is less. இப்படி படுத்துறீங்கன்னா snoring sound is less. If you sleep like this, 30% snoring sound, 50% snoring sound. If you sleep sound is, snoring sound is more, much more. Your frequency amplitude is very high. So before go to the bed, they give this type of dress. Here one punch. When he sleeps like this, immediately something else will hinge. Immediately he turns his position like this. Some saves from. So this is very, very ordinary. This is not the big invention. Very ordinary invention. He can make good amount of money only in US. இதை இந்தியாவில் வந்து நீங்கள் விற்றீங்கன்னா யாரும் வாங்க மாட்டாங்க. Okay. So the place of introducing your product is also one of the big thing you can make money. Where to introduce, when to introduce, all these things. There are so many things are there, so many inventions are there, but shortage of time. Any other questions you please ask, then that will be better. There is so many slides are there. Anyway, so already time. If you have any questions, you please ask. Yes, sir, please. Oh, sorry? Patent type is ordinary patent. You come to Indian Patent Office and file a patent is Indian patent filing. Then convention application. Using priority date, you go to other countries and file a patent means convention application. Then PCT application, Patent Cooperation Treaty, I said. PCT means we will forward your application to WIPO 152 countries. Then patent of addition. You can include some more things. And divisional application. There are so many things are there. These are the main 5 types of patents. Yeah.
Sir. and we are creating a new product, it is not possible to create a pattern.
Yes, that is called inventive step. Copying one portion from one invention, other portion from other invention, combining all three things you cannot make. That falls under inventive step.
What is the alternative for that, sir?
No, that is a efficiency part is there. Because of combining, I am getting this much efficiency.
Okay, sir. Okay, sir.
So previously the efficiency is less. Then we examine whether it's a remarkable efficiency or not.
Okay, sir.
The efficacy, all these points we check, then they will grant.
If it is output efficiency is high and optimized, then the patent will be possible.
Yeah. Because of combining this, I am getting more efficiency, the cheaper cost, cheaper process, all those things you can apply.
Okay,
Sir, I have some question. Can you, sir, give me some example of patenting in some process or methodology in terms of
In which field you want?
industrial engineering area?
Yeah. That
I'm
is,
not talking about any product development. I am just planning to patent some methods or some process. So can you give some example?
Yeah, the same patent, one claim is product claim. There is need not be the product claim, only the process claim, the step, the machine operation procedure, that itself you can, how the machine, first what we have to do, then how much time you have to wait, then what is the step 1, step 2, step 3, the steps itself is you can go for patent. That is a process and method of operation of particular things, and all these things you go for patent.
Like some technique or tools is already available, and I'm using that technique or tools to changing some layout of systems or anything, and application of that tools in a different steps. If I do it, so can it be patentable?
Yes, patentable.
Okay.
See, the thing is, patent in the thing, main thing is techno-legal draft. So drafting of patent application is very important. So many people, they may do the beautiful work, but the way of drafting they fails. Most of the Indian people, they fails in way of drafting. It's a techno-legal procedure. In the proper way, maybe for the European applicant, one helical spring it is there, means if he changes this procedure and we are getting more efficiency, the way of drafting he may get a patent. Our people might have do that 6-stroke engine, 8-stroke engine. Why to use the 2-stroke and 4-stroke? Even if you do 6-stroke means there is cleaning is possible, no dirt. But the way of drafting that matters. The patent language is very important. If you see 2-3 granted patents, you will come to the idea how to draft the patent.
Sir, I heard randomly about some idea patent, design patent or something like that. So what are the different type of patent we can file in terms of particular concept or a particular product or something?
No, it is a patent means it's a fully technical features available. How the technical features, how the circuits are attached with each other, how the engine efficiency improves, these things. But design means is the aesthetic appearance. Only that top view, front view, only that particular external feature. There is no technical feature involved in design. So same work, you can go for patent as well as you can go for design. For example, Prestige pressure cooker is there. In pressure cooker, the method of operation, what system, it is isolated system or whatever the system it is operating and how it is working, and all those things covered under patent. And design means the handle, sometimes the inner portion handle comes in outer portions, and that photographic view, that is design. And the same pressure cooker, they go for Prestige. They will get a trademark for that term called Prestige. And what the brochure or CD they are giving, that is copyright. These people have got all the 4 rights: patents, designs, trademarks, copyrights. Yeah. Previously that copyright with HR ministry, but now they changed to our ministry. It is only one copyright office available in India, that is in Delhi. That's with our office. It's attached with our office. No, you need to apply. Then we will check all those things, whether the procedure is properly followed, immediately copyright will be granted.
Sir, my one more question. Sir, whether we can able to make any name as a patent, for an example, the company name Prestige or
That is
something
trademark.
is there, right? So that, like that, suppose if I'm trying to formulate one catchy word as a trademark, whether I can able to file that?
Yeah. Whether it is available or not, you check. It should be distinctive, not deceptive. The trademark should be distinctive, not deceptive. So some people, it's what's happening is they got trademark for there are so many catchy words. When you apply, then those people comes in the middle and says that, sir, this is already trademarked by me. Then they sell the mark to even the domain. This type of things are there. Some people are having, they registered so many domain names. What happens? You 2 months, 3 months, you think about some domain name and you start applying. That time they come in the middle and says that I already got that right. If you want that particular domain name, pay 5 lakhs.
Okay, I understood, sir. In following that, in electrical there is one domain called Power Electronics. There is a company is there in, I think, Italy or Europe country. That company name itself Power Electronics. But Power Electronics is a totally domain in electrical engineering. So in their website and all, Power-Electronics, like that they are mentioning. So like that, in place of hyphen, if suppose I put some dot or some different letters or symbol into that, whether that can actually add?
We may not grant. For example, in Ray-Ban, what is the spelling of Ray-Ban? R-A-B-O-N means, instead of O, I put A means, but it should cause confusion to the buyers. Reebok shoes, there is so many shoes available. R-E-E-B-O-K means R-E-E-B-A-K. Sir, that's different spelling, you cannot say that. But because it creates confusion to the buyers, so we don't grant trademark rights to the people.
Okay, thank you, sir. Sir, where we can find this information, sir? These are all the names and all is already filed like that.
All the things are available in ipindia.nic.in website. In South India, only one office available, IPR office. That office in Chennai. Only one office in South India is Chennai. There is only 4 office, patent office, Chennai, Mumbai, Delhi, Calcutta. ipindia.nic.in.
Hello, sir.
Where is that
Actually,
fellow?
we have one more speaker waiting.
Okay, sir, my last question.
No. You can post the question to us. We will definitely seek answers from sir and we'll get back to you. Okay?
Thank you.
Or I will give my mail ID, you directly ask me. Okay,
sure.
No worry.
Sir is a speaker for our every induction program, right from the first program till now. Sir sessions will be there, so you can see it in the website also. Sir is our regular speaker, so you can post your questions to us and we will forward to the sir, because sir is our, right
Okay,
from
sir.
the first induction program we are calling sir for the delivering this lecture. So you can see right from the first induction program, you can see it in the website, because the next speaker is waiting.
You feel free to come to my office, okay? It's don't think that the government office means some myth it is created. It's not like that. You feel free to come to my office anytime you meet me and clarify your doubts. But definitely I will say you will not come. This interest you will not show. Will not come. Many people, they ask too many questions. That's all. They forget today.
See, we are trying to create awareness. Okay, so these are things that are giving you awareness. Please follow that. Okay, so thank you so much, sir, for your detailed discussions. Thank you so much, sir.